Hi everybody. I've been asked quite a few questions about why I in dialogue with Dan Neidle so much, and why am I posting so many messages and things on our Telegram channel and putting it up on various websites and through social media channels. Well, the reason I'm doing it is because there is a need to get the truth out there, but there's also a need to show our membership and our envoys and our membership of Republic of Old Souls that the damages that were caused to them last year, the 600 million of recoupments that were undermined, and the damage to me personally, where I've had to move to North Cyprus to avoid the 12-month sentence that flows from Order 34 2023, the FCA's rigged and legally a legal nullity, the legal nullity of Order 34 2023. I've had to come to North Cyprus so that I can carry on working for the benefit of our members and our envoys, but also so that I can quash or remove that 12-month sentence by basically annulling it, which I couldn't do if I was currently locked up in a prison cell. There's no way that I would be able to annul this legal nullity of the Order 34 2023. And because the establishment in the UK, and particularly the FCA, are working with their proxies, and the main one that they're working with is Dan Neidle. Dan Neidle has actually caused two heads of damage. There are two separate cases here. There's case number one, where Dan Neidle has been working with the FCA, and he is joined together with them in their malfeasance in public office by being their proxy, by promoting their narrative through his social media channels. He has caused me personal damages, and then Dan Neidle is also, by vicarious liability and also through the tortious interference into contracts, caused losses for our membership. So there are two cases. Now, ordinarily, and if you look into Dan Neidle in particular, you'll see that Dan Neidle, whenever he criticises somebody online through his large social media following of all the different channels that he uses, typically whoever it is he's criticising cannot sue him in the United Kingdom, because Dan Neidle gets what's called a Slapp order, and that means that the damaged party can't take on a lawsuit against Dan Neidle. And Dan Neidle also has set up this Tax Policy Associates as a not-for-profit, like a philanthropic platform that he's delivering a message through. And because it's a not-for-profit, you can't really sue a not-for-profit platform that doesn't charge anything for its services. So it's very, very deliberate how Neidle is able to pump out his narrative through his social media channels, working for the establishment as their proxy. They can't put media out because they would be too heavily criticised for doing it. But someone like Dan Neidle can put media out through his channels, through his non-profit platform, through the knowledge that anybody who pushes back against him normally would get a Slapp order, which means that they can't take the case on in the UK court. So Dan Neidle can carry on with his blogs and his reviews, and some of them are actually probably very, very accurate, and his research is probably very good, and he's probably warning the public about something or somebody who's causing harm. But in the case of Iain Clifford, he did no research apart from reading blogs like Simon Goldberg's blogs and reading other media content that's easily available on the internet. He's read Order 34 2023 and the sentence without realising that that's being challenged in the High Court, in the Court of Appeal. He's done no research. He never contacted me, never asked me any questions about what I do, how I do it, etc. So just to repeat again, I provide technical consultancy to the Republic of Old Souls, which is a 508c1a ministry, and I write technical papers for Ecclesia Law, which is a Wyoming attorney-in-fact law firm. I do not charge anything for my services. I never have done. I don't provide any regulated financial services. I never have done, except for when I'd had all the licenses more than 15 years ago, and I was licensed to provide financial services that required a license back then. Since then, all I've been doing is presenting webinars, putting together protocols and programs that the members of originally Matrix Freedom could have used, or now the Republic of Old Souls, where those members are engaging with an administration company that I don't run and have no shares in, that can assist them and facilitate their instructions to roll out a process that they have chosen to do and they're directing. The only thing that I've ever provided is information. So when Dan Neidle is claiming that I am a tax fraudster, that I practice pseudo-law and I practice as a free man on the land and a sovereign citizen, he's actually got no facts at all to base that on. So he's been criticising me for over 2 years with his blogs, his documents, his very sarcastic comments about what I'm saying in my webinars and in my documents, etc. But he's never done any research, which is quite interesting. Now, why would Dan Neidle not do any research? It's quite obvious. He's been asked to put this propaganda out there by the establishment so that because he thinks he's immune. If I ever fought back, he would get a Slapp order. If I ever fought back, I couldn't do because I'd be in jail. So he thought that he was completely in the clear, could do and say whatever he wants, because A, he's protected by Slapp orders, and B, he's got a non-profit platform, and probably C, actually, he probably thought that I'd get put in jail, and therefore I could never fight back. Well, I've got news for Dan Neidle, and he keeps claiming that I've never ever won a lawsuit. Well, up until 2024, I had a 100% track record winning lawsuits in the UK, in Ireland, in the USA, in Hong Kong, in Paris. I have a very deep track record of winning lawsuits that Dan Neidle, again, had done no research on, has no idea about all these different fairly high profile cases that I have won, and I haven't used lawyers to do it because I do my own work. As you can see from the papers I write, I actually do know my way around the legal system, and I certainly know how the art of legal warfare works. So this paper here is explaining how I am going to defeat Dan Neidle and the FCA, but not in the UK, because in the UK they will be protected by the judiciary, very, very likely, and it's very difficult to sue the FCA for their malfeasance. In fact, if you go and look into it, there's only one case that they've ever paid out on, and that's been scrubbed from the record. So you really have difficulty finding any cases where the FCA has ever paid any damages. So that's a bit of background. Now, what are we talking about? The damages to my reputation, to my career, to all of the businesses and ventures that I've set up over the last 15 years. Each one of them has been destroyed in an extraordinary vendetta against me being a whistleblower against the banks from 2008, 2009. It's all in documents that I've published on the Telegram channel, and there is actually a website that's been put together to cover it as well. So, and I've been interviewed many, many times. So the first claim is a personal claim. And what I'm claiming against Dan Neidle is the fact that I am the head minister of the Republic of Old Souls, which is a faith-based ministry created in the United States for the advancement of peaceful living, acting as a creditor, playing Monopoly at an advanced level, recouping signature credit, and operating within an environment that has its own infrastructure. That's what we believe in. That's what we're doing. That's what I work on all the time, is facilitating the build out of that. So as the head minister of the Republic of Old Souls, as a 508c1a faith-based ministry. What I say that Dan Neidle, joining together with the FCA, who's been, I say, have been playing out a vendetta against me, which is malfeasance in public office. It's all in my document I published a few days ago about the scandal being bigger than Hillsborough and the post office scandal, and it goes into all the background of that. I say that Dan Neidle is working with the FCA as their agent to push out this propaganda. So I say that the conviction of Iain Clifford Stamp, the body corporate, is deficient on 3 grounds. The first ground is that no prosecutor has ever been evidenced by the FCA. There's a name called Alistair Mackenzie, which they claim is a prosecutor, but he's not recorded anywhere in the FCA. Nobody can find him. The FCA can't confirm whether he's real. I say he's a phantom, and I say it's very deliberate that they've used a phantom called Alistair Mackenzie, but it's not a real prosecutor. He's not got the licence as a prosecutor. I say that the FCA have no evidence that belongs to me that they are allegedly investigating 45,000 documents which they claim that they seized from an office in London. I say that those documents don't belong to me, and the FCA have never been able to provide any proof that those documents do belong to me. I say they belong to Strax Capital Legal and Lightside Financial, which are both licensed firms licensed by the FCA. Then these aren't my documents. And I also say that that there is no service, that the FCA have never served any documents, or the courts never served any documents on a valid address. So if you don't have a valid service address for writs, warrants and orders, then those orders have no legal standing. So I say, for all those reasons, Order 34 2023 is entrapment by design. They've deliberately set it up to try and get me in jail, to get rid of me because I'm a whistleblower. I say that is religious persecution. I say that there is a case in the United States because as a head minister of a ministry, I am protected by Article 1 of the United States Constitution. I say that the malfeasance in public office by the FCA, which is well supported. If you read the APPG report on the Parliament's report on the FCA, how many times have they persecuted whistleblowers? And it's a very, very high number. I say that Dan Neidle is vicariously liable with the FCA, and that's the first case in the United States where he can't get a Slapp order just to close the case down before it even starts. I say that that's his Achilles heel, is that I have shifted the case to the United States. And I will only start the case when the UK Court of Appeal decision has been handed down, which is coming up very, very soon. And they're in a very difficult place. They've had the case now. It should have been put in front of a judge 3 weeks ago. It's gone completely silent. They already had the case from the end of 2025. They tried to reject the case because they knew that they couldn't get rid of it. It was very serious. It was very powerful. They tried to get rid of it. I put it back in there. They then didn't do anything with it for 56 days. I say that that's excessive formalism. I say that that's deliberate. Now they say they've put it in front of a judge. Well, a judge shouldn't take very long to quash the case and quash the sentence, but the 3 weeks has gone by and nothing's happened. So I'm going to wait another week, and then if they don't do anything, then I have some other strategies that I'm going to unfold. And then the next case is case number 2, where I say that Dan Neidle, because of his blogs, because of his websites, because of his allegations that I am a tax fraudster, I practice pseudo law according to Dan Neidle, I'm a free man on the land, I'm a sovereign citizen according to Dan Neidle, even though all of my research papers at Ecclesia Law criticises pseudo law, criticises free man on the land, criticises sovereign citizen movements, and critiques all of the various ideologies that they believe in, breaks them all down and tells people not to use them, they don't work. According to Dan Neidle, I am one of those people that I'm criticising on my research papers. According to Dan Neidle, I am a tax fraudster because I'm doing the 1099 OID signature credit recoupment. Well, it's not me that does the filings. I'm not doing the tax filings. WK, who's got a licence with the IRS is doing the tax filings, and he's doing them completely in line with my research, the Clifford Protocol, 100% lawfully, and there have been results, there have been recoupments successfully received by our members, and there was 600 million that went all the way through the IRS's algorithm, and it was all checked out in 2025, and that was undermined because the people that were running the trustee department of the Matrix Freedom undermined the recoupments because Dan Neidle convinced them through his blogs that they might have been involved in a fraud. So what did they do? They sent in fraud identification reports to the IRS because Dan Neidle was saying that it was all fraud and they didn't want to be involved in a potential fraud. So the whole programme was undermined as a result of Dan Neidle's blogs. And that's what I say, that is tortious interference. I also say that that is vicarious liability. Now again, the case against Dan Neidle is not in the UK where he can get a Slapp order. It will be in the United States, and it will be for 120 million, and the case will be taken on by the OSN Foundation, which is a Panama foundation that stood to receive 20% of the 600 million, that's 120 million there, because that's how much it was going to be receiving under contract to receive it from each of the 3,000 grantor trust tax filings that have been done by a professional tax licence holder and his organisation, WK, and it had all gone through the IRS's algorithm until it was undermined as a result of Dan Neidle's blogs. So I say that that is the damages that the foundation, the OSN Foundation, is going to be claiming against Dan Neidle. So the first case is Iain Clifford claiming against Dan Neidle and the FCA, but primarily Dan Neidle, because it's very difficult to get a sovereign entity to pay out. But so Dan Neidle is on the hook there on case number 1. And case number 2 is Dan Neidle again, because he's vicariously liable and has undermined the recoupments, and he's interfered with the contracts, which is a tortious interference with 3,000 contracts. And the biggest contract is the OSN Foundation. And I say that Dan Neidle will lose these two cases because he can't use Slapp orders because of what I've explained, and it's all in these documents. And I say that the cases will be taken into a jurisdiction that he can't rig. And I say that the courts that may be employed here, because I haven't decided exactly which courts to go into, all described here. It could be Wyoming for one of the cases, it could be Panama, it could be other states of the United States. It all depends on what happens with the Court of Appeal case, which is coming up very, very soon. And the Calder effect. See, Dan Neidle thinks that he's probably immune in the UK and he's got no risk somewhere else because he's got a non-profit platform. Well, he's personally liable, and his non-profit platform probably has got insurance. If he's as smart as he claims he is, he would have taken out insurance just in case there was ever a claim against him. So for all of those reasons, and it's all in this document, the conclusion of this is my research, you don't have to agree with it, of course, you may disagree with it, is that there is going to be a total collapse of Dan Neidle. He may end up having to claim on his insurance. If he hasn't got insurance to cover these liabilities, he may end up being made bankrupt. Thank you for watching.